My name is Carrie Faniff, and I'm the Vice President of Loss Prevention at Texas Lawyers Insurance Exchange. Today, we're going to do a Fast 15 on legal malpractice liability. So, what that means is we're going to spend about 15 minutes talking about a cause of action against lawyers for legal malpractice and what that means at a pretty high level because we don't have time to go into the weeds. A little bit about me before I go on. I have been on staff at Texas Lawyers Insurance Exchange since July of 2024. Before that, I was a lawyer in private practice, and I represented lawyers defending them in claims for legal malpractice or other lawsuits against them and in grievance proceedings before the State Bar of Texas. So that's why I kind of know what I'm talking about and can talk to you about what a legal malpractice claim means in Texas against a lawyer. Now, again, we're going to go pretty high level today. We don't have time to go into all of the intricacies regarding a claim against a lawyer, but we'll talk about the elements of a cause of action and a few of the unique aspects of what that means. So again, starting very high level, in Texas, the Texas Supreme Court has told us that a cause of action or a claim against a lawyer is based on negligence. And that was the Cosgrove v. Grimes case in 1989. So let's talk about what that means, just jumping right into it. The elements of a legal malpractice claim in Texas are not unique to negligence claims. They're pretty standard for what you would have to prove in any negligence claim that sounded in tort. So first, was there a duty that the attorney owed the plaintiff? So duty, did the attorney breach that duty? Was the breach a proximate cause of the plaintiff's injuries or damages, and did damages occurred? So you have four elements: duty, breach, cause, injury. Again, not different from any other negligence claim that sounds in tort. So the first question you're going to ask yourself is there a duty? So in Texas, generally, lawyers only owe duties to their clients. And in general, a non-client cannot sue a lawyer for negligence. So we have what's called a privity requirement. That's what that is. Was there an attorney-client relationship with respect to the matter at issue? If there was not, then generally there was no duty of care. So you've knocked out the first element of your cause of action, and on that alone, the claim would fail. It would not go any further. Now, importantly, whether or not there's an attorney-client relationship in Texas is based on an objective standard of what the parties said and did, not on anyone's subjective beliefs. And it has to be a mutual agreement between the lawyer and the client. So the lawyer has to agree there's an attorney-client relationship, and the client has to agree. And generally, the agreement is, what are the terms of that relationship? How much is the person paying? What is the scope of the representation? But a client or a person's subjective belief that someone is their lawyer is not going to be enough to establish that attorney-client relationship. So, question number one, is there a duty? If there's not, we go no further. But assuming there is a duty, then the next question you would ask yourself is, well, what is that duty? And in Texas, the standard of care for a lawyer is what a reasonable and prudent attorney would do in the same or similar circumstances. Now, the conduct of the lawyer is going to be judged on what the lawyer knew at the time. What were the particular facts and circumstances that existed at that time that would cause the attorney to do something or to not do something in the representation? There's no Monday morning quarterbacking. In other words, you can't look and with hindsight and say, well, you should have done this, knowing what we knew, knowing what we know 6 months down the road or 2 years down the road. No, it's what did we know at that time? So that's the duty of care that you're going to look at. And we're going to talk about experts in a minute, but you're generally going to have an expert, another lawyer, who's going to have to testify about what that duty of care is. What would a lawyer in those circumstances, a reasonable and prudent attorney, have done? So then once you've established, there's a duty, what is the duty? The next question is, did the lawyer breach the duty of care? So what the case law tells us is that if an attorney makes a decision, which a reasonable and prudent attorney could make in the same or similar circumstances, then it's not negligence, even if the outcome is bad, even if the outcome is undesirable. Attorneys are not strictly liable for their clients' unfulfilled expectations. So, for example, in a litigation case, each side wants to win. Your client wants to win that lawsuit. They either want to win as the plaintiff or they want to come out owing no money as the defendant. Well, one side in that equation is going to lose. Just because you lost the lawsuit does not mean that the attorney was negligent. It just didn't go your way. And that's life, and that happens. So an attorney that makes a reasonable decision in the handling of a case may not be held liable even if that decision proves to be imperfect. Because what are they judged on? Well, is that a reasonable decision that a lawyer could make under those same circumstances? Again, sometimes things don't turn out your way. That doesn't mean the lawyer did anything wrong. So an example of something that would be a breach, however, because I don't like to just talk at you, I like to try and give you some concrete examples, is let's say your client was in a car accident on May 2nd, 2000, and there's a 2-year statute of limitations. A reasonable and prudent attorney in those circumstances would file the lawsuit for their client before the 2-year statute of limitations runs on May 2nd, 2002. So a failure to file the lawsuit timely would be a breach of the standard of care. So in that situation, you've established duty and breach. Now, whether that was a proximate cause of damages is the next inquiry that we're going to talk about. So there's a duty. What is the duty? The duty has been breached. Now, again, did that breach cause damages? What would have happened if the lawyer had not been negligent, if there had not been a breach? And if the outcome wouldn't have been any different, then you do not, in a very shorthand way, you do not have proximate cause. So you can have a breach and not have causation of injuries. And what the Supreme Court has said time and time again is that breach of the standard of care and causation are separate inquiries. An abundance of evidence as to breach, so we can say there was a breach all day long, is not a substitute for the deficiency of evidence of causation. So even when breach is admitted, even when the lawyer's like, yep, I didn't do what I was supposed to do, there's not going to be a finding of liability unless you also establish causation. So causation is never presumed. So let me go back to our car accident example. Our lawyer failed to file the lawsuit before the statute of limitations ran. So we definitely have a breach. But if that plaintiff would have lost the lawsuit anyway, let's say it wasn't a very good case. Let's say the evidence actually showed that the plaintiff was the cause of the accident and he was never going to win at trial, then there is no causation of injury. So the fact that you have a lot of evidence of breach over here isn't going to matter if that plaintiff was always going to lose the lawsuit. So that's where you have a deficiency in your causation evidence. And so again, the Texas Supreme Court says you have to have evidence of both in order to move forward. So when I was defending lawyers in malpractice cases, we would often win our cases on the causation element. The causation element is fairly difficult for a plaintiff to establish just because of the way that the law is, and it is often difficult to connect the breach to an injury. So in Texas, proximate cause is made up of 2 factors. And again, the Supreme Court has said you have to have all of these factors present. So you have cause and fact. What does that mean? It means a showing that the act or omission was a substantial factor in bringing about the injury and without which harm would not have occurred. So what we call that in shorthand is but for causation. But for the lawyer doing something wrong or not doing something at all, what would have happened? Would that same outcome have occurred? So that's cause and fact, and you have to show the substantial factor, and you have to show the but for cause, and then you also have to show foreseeability. Should the attorney have anticipated that there was going to be some injury from the negligent act or omission? So again, going back to our car accident example, the lawyer in that situation should foresee that if he doesn't file the lawsuit timely, then the injury is that that plaintiff never gets to bring the lawsuit. Again, you still also have to have cause and fact. So it was foreseeable, but here you may not have cause and fact. And that's why, if the plaintiff was going to lose a lawsuit anyway, you're not going to have causation. But you've got to have cause and fact and foreseeability. Now, what you can't have, what is not good evidence of causation, is speculation. You would see this a lot in cases where the plaintiff might have a different kind of lawsuit. Maybe it was a business lawsuit, and they were suing for maybe breach of a franchise agreement. And they would say, well, if you hadn't screwed up my lawsuit against the franchisor, I would have made all of this money. I would have made all these profits. And that is really speculative, especially if that person has never run that kind of franchise before, that kind of business before. And so that's not going to be sufficient to get you across the goal line to show that there was proximate cause. It's too speculative. So speculation or surmise is not going to be sufficient evidence to prove causation in a legal malpractice case. So proximate cause, I'm not going to go into more here, but this is really the meat of the issue. And if you were handling a legal malpractice case, you would need to do a fair amount of research on issues related to proximate cause. Because again, this is pretty much where a case breaks down if you're the plaintiff, or where we would win on the defense side. So another issue that is unique to legal malpractice cases that has to do with proximate cause, we're still talking about causation here, is the case within a case. So essentially, if you have a legal malpractice case that arises from an underlying lawsuit, so lawsuit 1, where the negligence allegedly occurred, was in itself a lawsuit. Let's go back to our car accident example. That is a personal injury lawsuit. That's lawsuit number 1, and we're saying the lawyer somehow screwed up lawsuit number 1. Then you have lawsuit number 2, which is the malpractice lawsuit. So what a case within a case means is we are trying 2 cases in one. We are trying the underlying car accident case, lawsuit number 1, and we are trying the malpractice case, which is lawsuit number 2. And that plaintiff has to prove all of the elements of proof related to the first lawsuit and the elements of proof in the malpractice case. So a plaintiff who is bringing a malpractice claim against their lawyer because they're complaining they lost their first lawsuit must prove that he or she would have obtained a more favorable result in the underlying litigation had the attorney conformed to the proper standard of care. So the plaintiff is saying, I would have won that case if you hadn't screwed it up. They have to prove that. And so that's the traditional means of resolving what should have happened in the underlying case. If you are the defendant, what you are saying is, I would not have lost that lawsuit, or I wouldn't have lost as badly. You caused me to have a jury verdict against me for $50,000. If you hadn't let this evidence in about damages, it would have only been $20,000. Whatever the issue is, you have to show that you would have obtained a more favorable result, but for the lawyer's malpractice in the first lawsuit. So I mentioned before that we were going to talk about experts. The thing about legal malpractice cases is that experts are required to show breach, to show what the duty is, breach of the duty, and causation. You can't just have expert testimony on one of those elements. You have to have them on all of them, because most of the time, the connection between those things is beyond what a layperson jury can understand. And there are cases they're pretty rare and unique, however, where you might not need expert testimony on one of those elements. But again, that's pretty unique. For example, you might not need expert testimony to tell you that failing to file the lawsuit on time is a breach. However, you would still need expert testimony to link up the breach to the causation of injury. So experts are generally required in these cases, and the better default is to have the expert, not try and argue that for some reason an expert would not be required because it's so obvious what occurred. just, a few things, and I got to put on my glasses to read this list, but, expert testimony on causation is required unless the connection is within the fact finder's ordinary experience. Usually it is not. It's required when the issue is not one that laypersons are competent to make. That is most cases. It's usually required when adequacy of an investigation or soundness of an opinion is at issue. When you're talking about the complexities of trial practice, you're going to need an expert. And when it involves a case within a case. Now, if your first lawsuit required some kind of expert testimony, let's say you needed a doctor to come testify in the underlying personal injury case about injuries, you need that expert in your legal malpractice case and a legal malpractice expert. So any experts that were required in case number 1, you're going to need to prove your case within a case in lawsuit number 2. All right, so we have talked about duty, breach, proximate cause, and now we're going to talk about damages, which is the 4th element. So in a legal malpractice case, foreseeable damages are those proximately caused by the negligent act or omission. That's a pretty broad and vague term. But what I can tell you are some damages that are not available most of the time. Most of the time, mental anguish damages, my lawyer's conduct caused me to have mental anguish. That is not recoverable. The caveat to that is if mental anguish damages were available in the first lawsuit, that would be an element of recovery from the first lawsuit, but it's not an element of recovery because of something your lawyer did to you that caused economic damage to you. Attorney's fees are not available as, I'm suing you for negligence, so I get attorney's fees. No, the only time attorney's fees are going to be available is if because the lawyer did something in the underlying case that caused you maybe to have to hire a new lawyer to fix the problem by the first lawyer, or cause you to have to incur appellate fees that you wouldn't have normally had to incur. Those can be recovered as damages from the underlying matter, but not attorney's fees from the malpractice suit itself. Again, there's a Supreme Court case on that you should look into if this is your issue. Lost punitive damages, there's no case that says those are recoverable. And contingency fee offset, there's been no authority that says that is recoverable, although that is a matter that could be debated either way. Damages, when in general, the way that you measure damages in a legal malpractice case is the difference between the result obtained for the client and the result that would have been obtained with a malpractice-free lawyer. So if you had competent counsel, you would have had this result. Instead, you didn't have competent counsel, you had that result. What's the difference between those two things? And when you're talking about an underlying lawsuit, it's the measure of damage that would have been recovered and collected if you're a plaintiff in the underlying lawsuit. So again, going back to our car accident example, if I'm Patty plaintiff, I'm going to say I would have won the underlying car accident lawsuit. I would have recovered. I would have won. The jury would have awarded me $50,000, and I would have been able to collect that from the person's insurance carrier. They had Geico. They had a policy limit of $100,000. I easily would have been able to collect $50,000. Where plaintiffs sometimes fall down here is they don't understand they have to prove collectability. So you have to show a jury would have awarded me this, or I would have recovered this, and I would have collected it. That's if you're a plaintiff in your case within a case. So that's a general, very high-level view of a legal malpractice case based on negligence. Oftentimes, plaintiffs will also try and sue a lawyer for other causes of action: breach of fiduciary duty, breach of contract, fraud, negligent misrepresentation, and deceptive trade practices. In Texas, we have something called anti-fracturing. In general, if the crux of your complaint boils down to my lawyer did not do a good job, you're complaining about the quality of the professional services, or that the lawyer failed to exercise the degree of care, skill, or diligence that a professional of ordinary skill and knowledge would exercise, that's going to be negligence all day long. It doesn't matter that you try and fracture it into other causes of action, maybe to get some additional damages or have longer statute of limitations periods. It's going to boil down to one claim for legal malpractice. The Texas Supreme Court and many, many courts of appeals have said that repeatedly for many years. Now, that doesn't mean you can't ever have a separate cause of action for one of those things, breach of fiduciary duty, breach of contract, but it can't be a complaint in general that your lawyer failed to do a good job. It has to be something more than that. Typically, we would see where the most successful carve-outs have been in breach of fiduciary duty. So, of course, a lawyer is a fiduciary. They have to act with integrity and fidelity, good faith and candor and openness, and disclose all material facts. And so, where plaintiffs have successfully alleged a separate cause of action for breach of fiduciary duty is when a lawyer very clearly elevates their interests above the client's interests and receives some kind of improper benefit because they did that. And so, when you're trying to decipher between a breach of fiduciary duty claim as opposed to a negligence claim, you're going to look at, did the attorney obtain an improper benefit for breach of fiduciary duty? Did the attorney place his or her interests above the client's? And then again, a negligence case is just, did the attorney represent the client with the requisite skill level? And the focus is on the quality of the lawyer's work. So that's kind of the most obvious difference that you would see in perhaps a different cause of action against a lawyer. And then the cases talk about what a breach of fiduciary duty most often involves: failure to disclose conflicts of interest, failure to deliver client funds to the client, as I mentioned, placing your personal interests above the client's interests, self-dealing, and making misrepresentations. So that's might be where you have a separate cause of action for breach of fiduciary duty. So that's our Fast 15, and it actually ended up being a Fast 20. But I hope you enjoyed the presentation, and contact me if you have any further questions at rskmgmt@tlie.org.